Good morning, everybody. I just wanted to go over the housekeeping one more time, as we had a lot of participants coming in and may have missed a few things. So just a reminder with your logins, make sure you log in and log out at the end of the session so that Patricia can log you properly to record your professional development. Please make sure your name is who you are. If your name is not correct on the display, you're not going to get your PD allocated to you properly, and Patricia won't know who you are. Surveys, we've got some surveys happening. Please, we use that feedback, and at the end of these sessions, we'll have some prizes to give away. And you can stay connected in two ways. One, I know all of you have probably already been into the Facebook group, but just pop in there, as well as we've got the Zoom lobby where you can pop in and out throughout the day. And last of all, Q&A goes into the chat. So just a few things. And I think that covers all of it. And if you have any more, we'll pop in later. Oh, yes. And we've been asked if there's any videos of these sessions. They will be on the website. So please, the recordings will be done afterwards. And we're going to go over to Tajveer.
Good morning, everyone. Our next speaker is Marriner. Lee's practice focuses on insolvency, including bankruptcy and restructuring, as well as receiverships, foreclosures, creditors' remedies, security realization, and other commercial matters. He assists trustees, receivers, directors, shareholders, creditors, debtors, and other parties involved in commercial disputes. Lee also advises housing cooperatives on various issues, including rules and occupancy agreements, membership relations and terminations, contracts, policies, human rights claims, and later litigation.
Enter your participant ID followed by pound. Otherwise, just press pound to continue.
We worked in a broad litigation practice that included commercial, real estate, corporate human rights, and estate litigation. In this practice, he was involved in several trials, appeals, and other hearings. Please join me in welcoming Lee Marriner.
Thanks very much for the introduction, and thanks everybody for joining. Today I'm going to give an overview of a few different options that insolvent corporations have to deal with their issues. As a bit of a roadmap, what I'm going to do is review two broad categories of what I'll call informal options. Those are more negotiations and agreements between a company and its creditors. And that's outside of a formal legal proceeding. And it would typically be a way to give a company breathing room and time to get through a difficult situation without having to resort to a formal legal proceeding. The second broad category is the formal options. Those are options that are provided by legislation and are overseen by the court. I'm going to go through two formal restructuring proceedings. The first is called a Division 1 proposal, and that's under the Bankruptcy and Insolvency Act. And the second is a proceeding under the Companies Creditors Arrangement Act. After that, I'll just briefly touch on bankruptcy. To put the presentation in some context, we're now, I think, hopefully moving out of the pandemic. But we remain in very uncertain times. Canadian companies still possess very, very high levels of debt. The general kind of picture is pre-2020, there was quite a steep rise in debt levels. That spiked during the pandemic. It's since come down a little bit, but we're still at very historically high levels. On top of that, as I'm sure most of you are aware, lots of the government supports that have been provided in the pandemic are beginning to expire. Some have expired, some are being phased out, and it's more of a targeted support system. And lastly, many businesses right now are facing very, very serious supply chain issues and inflationary pressures, which are just making things even more difficult. So all of that creates a lot of risk and a lot of uncertainty, including insolvency risk. So before I turn to the actual options, it's important to actually define what insolvency is from a legal perspective. And that's especially important because insolvency is actually a prerequisite to some of the formal proceedings that are provided by federal legislation. And proof of insolvency is actually required to initiate those proceedings. The key point here is that insolvency is legally a description of a state of affairs. It's a set of circumstances that a corporation is in, and that's opposed to a formal legal status. So that can usefully be compared to bankruptcy. A bankruptcy is a formal legal status of an entity, which can result from insolvency, but insolvency is just the state of affairs and a set of facts that exist. I'm going to briefly touch on two broad tests, the first being a cash flow test for insolvency, and the second being balance sheet. So firstly, onto cash flow insolvency. In the Bankruptcy and Insolvency Act, it's kind of looked at in two different ways. The first is more of a forward-looking test, and then the second is a bit backward-looking. So in the forward-looking sense, the Act defines it as an inability to meet obligations as they generally become due. And that will involve a determination of whether a debtor is able to make payments on an ongoing basis. And it's important here to make it clear that that's not just about the availability of liquid funds. If a business has a line of credit or assets that are usually sold in the course of its business, and in those ways it can meet its obligations, it's not insolvent. The backward-looking sense looks at whether a debtor has stopped paying obligations in the ordinary course of business as they became due. Each of these ways, the court's going to look at an inability to make payments. And it's not anything to do with an unwillingness. There's no way for a debtor to choose to stop making payments and then decide to be insolvent. It's strictly about an inability to do so. And as with many things in law, it's not a simple mathematical calculation. There can often be disputes about whether longer-term obligations ought to count in that analysis. The second general test is the balance sheet insolvency test. That again is provided for in the Bankruptcy and Insolvency Act, and it's under the definition of what an insolvent person is. This one arises when a debtor's obligations exceed the debtor's assets. So it's more of a snapshot in time net worth analysis. That analysis inevitably requires some valuation of a debtor's assets. Value here is going to be assessed as either fair value or the value of the property in a liquidation, essentially. But the assets, because it's a snapshot in time, aren't going to include any future assets or future increased value of the assets or anticipated profits. That then is measured against the obligations of a company. And again, it's not always a simple analysis, and there can be disputes about what ought to be included. But in general, longer term obligations and contingent obligations can be assessed. So with those legal definitions in mind, I'm going to turn to some of the options and begin with the informal options. Again, those are options that are available to address a situation of insolvency outside of a formal proceeding, either by negotiation or just internally in a company. It's not strictly the case that they're only available to insolvent companies. And in fact, in some circumstances, they're actually useful ways to avoid an insolvency. And in general, being proactive and trying to deal with a situation and with creditors before insolvency arises can avoid insolvency altogether. And at that stage, there's often a lot less pressure from creditors, and there are a greater number of solutions that might be available to the company. And the options I'm going to touch on are forbearance agreements, workouts, and restructuring. So firstly, a forbearance agreement is a contract that can be entered by a debtor with a creditor after there's a default. That default is most commonly going to be a missed payment. The basic or essential feature of that contract is an agreement of the creditor not to enforce its right to sue for a very specific period of time. Typically, it will also include an agreement of the creditor not to enforce any security interest it has for that defined period of time. The obvious benefit for the debtor is to just buy time. That during that time, it can rearrange its affairs, avoid the imminent pressure that a creditor is putting on the debtor, and just explore refinancing options, or even just catch up on the payments that are owing. In exchange for that, the debtor is going to have to give something up. In reality, it often has to give up quite a lot. And just to give some examples of the things that creditors ask for, a very common one is an acknowledgement by the debtor that the amount of the debt is correct, the creditor's security is valid, and that the debtor doesn't have a defense. The idea being here to make it easier for a creditor to enforce its rights if the debtor defaults again. And sometimes that can even go as far as having a debtor sign a consent to judgment that can then be filed in court if there's a further default. Another thing that's typically included is for a debtor to agree to an increased interest rate on the debt. And a creditor can frequently require a debtor to pay legal fees that it's incurred in negotiating the forbearance agreement. That can either be payable immediately or added to the debt. Sometimes those agreements ask for consent to the appointment of a receiver if there's a further default. And again, all of these things are to try to make it easier for the creditor if there's a further default, things go back into a messy situation. Creditors sometimes ask for additional security for the debt. That can include security over additional assets or additional guarantees from a director of the company. The debtor here has to take some care because other creditors can take the position that additional security granted is either a fraudulent conveyance or a fraudulent preference. Those are a whole other topic, but just in brief, a fraudulent conveyance is a disposition of assets that hinders, delays, or defrauds other creditors. And a fraudulent preference is a disposition of assets that prefers one creditor over another when a debtor is either insolvent or on the brink of insolvency. So there's intricacies to both of those doctrines, but it's just something that needs to be kept in mind in that context. Now, the second informal option that a debtor company has is referred to as a workout. This is less like a forbearance agreement, an agreement between one debtor and one creditor after a default. A workout is more of an option for a debtor to reach an agreement with its main creditors. For what's essentially a turnaround plan. Again, the benefit to the debtor and the creditors is to manage a short-term issue and to manage it without interrupting the business. The ultimate goal, of course, is for this agreement to deal with that short-term issue and avoid the insolvency getting worse or leading to a bankruptcy. There are different ways that it can be structured. But it can involve creditors just providing temporary financing just to bridge across the difficulties, to delay or reschedule debt payments, and just to see the debtor through to the other side of the issue. Again, the debtor is going to have to give something up in return. That can require the debtor, for example, increasing its reporting requirements. Sometimes creditors can appoint a third party to oversee the debtor's operations over the course of the turnaround. But the point is that the debtor's going to have to give something up to achieve the turnaround plan and reach an agreement with its creditors. Practically, a workout is a lot easier to achieve in a situation where there are fewer creditors. And often when those creditors are a bit more sophisticated, because it's the sophisticated creditors and a few of them who are more likely to come together and structure the turnaround plan in a workout. If there's a large number of creditors, it can be difficult to work it out. It only takes one or more creditors to not agree to the overall plan and to continue to try to collect their debts for the whole thing to fall apart. Creditors can start racing to enforce their rights, and it leads to that kind of chaos that the whole point of the workout is to avoid. And obviously, this is all subject to an agreement with the creditors. There's no way to force an unwilling creditor into the plan. I'm going to come to it later, but that's something that can be done with creditors in a formal proceeding. Now, the last informal option I'm going to touch on is just restructuring. Now, that is an option for a debtor that doesn't require agreement. It's more of an internal process. Again, that can take many different forms, including sales of assets within the debtor company, injections of funds to refinance, or just reduction of expenses. Again, in that insolvency context, it's very important to be alive to potential fraudulent conveyances and fraudulent preferences, because that can have severe consequences, and eventually a creditor could look to unwind something that was done within the restructuring. Now, if any of those options fail, or they really weren't a practical option in the first place, An insolvent company is really left with the formal options, and those are provided by two federal statutes, the Bankruptcy and Insolvency Act and the Companies Creditors Arrangement Act. There are three different formal proceedings I'm going to go through. Two of those are restructuring proceedings, one of them under each statute, and the third is bankruptcy. The three key overall differences from the informal options are firstly that they are structured proceedings. So they're structured according to rules in the legislation and court supervision. So there can be very important deadlines that apply, and the court's going to oversee the process and approve the process as it progresses. The second key difference is that a stay of proceedings applies. I'm going to get into that in a little more detail, but in general, that prevents all creditors from taking any steps over the course of that proceeding. Following what I just said about a workout scenario, when there's a lot of creditors, it can be particularly beneficial as it stops all of them short and gives the insolvent company breathing room. The third key difference from the informal options is that in the restructuring proceedings, dissenting creditors can actually be compelled to be bound to the proposal or the plan, and that can happen in a couple of ways. Most commonly by a majority of creditors voting to approve a proposal or a plan, which after subsequent court approval is going to bind even the minority who voted against it. And the second way is just a court approval of, for example, a sale of assets over the objections of certain creditors. So now, the first formal option is a Division 1 proposal. Division 1 here refers to the particular division in the Bankruptcy and Insolvency Act, which creates this option and sets out a set of really specific rules that apply. The essence of this proceeding is that the debtor is able to make a proposal to its creditors, and that's essentially an offer to all of the creditors or some of the creditors to satisfy the debtor's obligations on different terms than those initially agreed. The creditors then vote to accept or reject that offer. Those proposals can take many different forms. Typically, a creditor will be offered to take less than it's owed and over a longer period of time. Another common one is for a creditor to accept equity in place of its debt. Or a proposal can just involve a sale of particular assets of the debtor and division of the proceeds among certain creditors. It's not completely open-ended in what a proposal can do. There are some restrictions, and there are some terms that also must be included. So I'm not going to get into all of those details, but the general aim here is for a debtor to offer creditors more than they would receive in a bankruptcy scenario. And that then, of course, leaves a debtor with two options: accepting a proposal and taking something, or rejecting it, pushing the debtor into bankruptcy and taking less or potentially nothing. If that proposal is approved by the creditors in the court, the debtor avoids bankruptcy. It's just then bound by its obligations in the proposal. Everything moves forward. Now, there are two different ways to kick that process off. The first is to file that proposal right away. That would involve contacting a licensed insolvency trustee who can help the debtor formulate a plan or proposal, which is then filed with the trustee, presented to the creditors, and the creditors then vote on it. The second way is a much more common way that it's done, and it's by filing a notice of intention to file a proposal. That is just a notice, I mean, the clue's in the title, that a debtor is going to file a proposal. And the key with that one is it's a simpler form, and it gives a debtor an initial 30-day period where a stay of proceeding applies, and the debtor can then, in conjunction with a trustee, look to develop a proposal. And it's more common really because in most scenarios, a debtor needs that stay of proceedings quickly so that it can actually negotiate, work on a proposal, and come up with one that's actually going to succeed. So the key feature that I just mentioned is the stay of proceedings. And just to give a little more detail, it's automatic on the filing of either the proposal or the notice of intention. It's not the case that a debtor has to run off to court and bring an application for the order. And that automatic stay prevents creditors from commencing an action against the debtor, continuing an action against the debtor, and also from seizing any property. There's two exceptions that I'll touch on. One is if a creditor's already taken possession of property before the filing. In that case, it's a bit too late. That secured creditor is able to continue enforcing its rights against the property it's seized. And a second exception is if a creditor has issued what's called a notice of intention to enforce a security, and they've done so more than 10 days before the filing. In that case, that particular secured creditor is able to continue enforcement. So, I mean, practically, that leaves the debtor, when they receive a notice of intention to enforce a security, to very quickly file the notice of intention, to file a proposal, and prevent that secured creditor from enforcing its rights. Otherwise, though, other than those couple of exceptions, the minute the proposal is filed or the minute the notice of intention is filed, all creditors are basically stopped short. That then gives the debtor some time to develop its proposal, negotiate with creditors. And there are some other steps that a debtor can take during that period, and they're specifically permitted by the Bankruptcy and Insolvency Act. One would be a disclaimer or a termination of a contract. That would let a debtor just walk away from a contract, essentially. If the trustee agrees with that step, it's up to the other party to the contract to object to it and bring an application in court and oppose it. If the trustee doesn't agree with the debtor's proposed termination of the contract, that onus is flipped, and it's then on the debtor to bring an application and try to have the court agree that it can walk away from that contract. The second common restructuring step that the Act permits is a sale of assets outside of the ordinary course of business. So that's going to be assets that are maybe fixed assets, not inventory, of course, anything the debtor wants to realize the proceeds of and potentially use in the proposal process. That debtor can bring an application in court, have that sale approved in the context of the proceeding. And the key benefit there is that the debtor, by doing it in the formal proceeding and seeking court approval, doesn't have that same risk outside of a formal proceeding of another creditor objecting, saying it's a fraudulent conveyance or a fraudulent preference. The application is brought with notice to all creditors. They can oppose it. If the court makes the order, the sale is approved and there's no risk. Now that stay of proceedings, just before I move to the approval stage, I should make clear it's not indefinite under the Bankruptcy and Insolvency Act, and that act is actually quite strict in establishing some deadlines and timeframes. So I mentioned that the stay of proceedings is initially in place for only 30 days if a notice of intention is filed. But a debtor can apply for extensions, again, just to give it more time to work through the situation, to restructure, to try to develop the plan. Those extensions can only be up to 45 days each. And the debtor has to show to the court that it's acting in good faith and with due diligence, that it's likely to make a proposal, and that there's no material prejudice to creditors if an extension is granted. The overall cap is essentially 6 months. So cumulatively, those extensions with the initial 30-day period cannot go longer than 6 months. That caps the overall length of a Division 1 proposal process. And the deadlines are extremely significant in that process. Because if a debtor doesn't manage to file a proposal within the time required, so that whether that's in the initial period, an extension, or the ultimate 6-month period, that debtor is deemed bankrupt, and the process is over. So in terms of approval of the proposal, as the slide indicates, it only takes effect if it's approved by both the creditors and the court. And it'll only be binding if the debtor meets both of those hurdles.
You're going to have another.
So dealing first with approval by creditors, after the proposal is actually filed, a meeting of creditors has to take place within 21 days. The proposal trustee will file a written report, which is going to set out a lot of information about the debtor, steps it's taken, and information about what the effect of the proposal will be. And that helps the creditors make a well-informed decision when it comes time to vote. Creditors themselves have to file a proof of claim with the proposal trustee, basically demonstrating that they are a legitimate creditor, and they then get to vote in person, by proxy, or by voting letter. At the approval stage, creditors, they vote by the class that's created by the proposal itself. So it's not as if there's one big pool of all creditors that vote together. The proposal can split groups of unsecured creditors. It can split groups of secured creditors too. And proposals don't necessarily have to be made to secured creditors. So each class votes as a class, and a majority is required in each class, which is a majority in number, so the number of creditors who are voting in that class, and 2/3 in value, which is 2/3 in value of the claims in that class. And I mean, this is a really key feature of the formal proceedings and the Division 1 proposal, in that a majority of creditors, if they vote in favor of the proposal, are able to really cram down the minority creditors and compel them to come along with the plan. And that proposal, if it gets through the approval stages, is going to bind the creditors who voted against it, if they're in a minority. That means it can ultimately be quite critical how the proposal creates classes, and also what a particular class of creditors is given in the proposal. If the proposal involves a large number of creditors, given the requirement that there be a majority in number, it can be important to split classes and give those classes enough that will get the majority that's required to move on to the next stage. As set out on the slide, there's some consequences if it doesn't hit this approval. If unsecured creditors don't approve, the debtor is just deemed bankrupt. And again, that proposal is over, the proceeding's over, the debtor is bankrupt. If secured creditors don't approve, it's slightly different. There's no deemed bankruptcy, but the proposal will simply not apply to that class of secured creditors. That, though, I mean, while there's no deemed bankruptcy, it can practically have the same effect if secured creditors are then free to enforce their security, seize assets and equipment, can really drive the debtor into the same result, which is bankruptcy. So then the next stage is the court approval. So assuming a majority of creditors have approved the proposal, the court then considers a three-part test. Firstly, whether the terms are reasonable and benefit the general body of creditors. Secondly, if it's made in good faith. And thirdly is more just a formality issue, whether it's got the required terms and is in the correct form according to the legislation. Again, the consequence of the court not approving are serious in that the debtor is just deemed bankrupt, proposal proceeding is over, and the proposal trustee will become a trustee in bankruptcy. Now, assuming that it gets through the two hurdles of creditor approval, court approval, the proposal then becomes a binding contract. It's binding on all creditors that the proposal was made to. And it would completely change the debtor's obligations with those creditors. There's no way for a creditor to look behind the proposal and go back to its original contract. It will have been changed. Once it's binding, it's of course on the debtor to actually implement that proposal and perform its obligations in the proposal. And that can happen over a period of time, but if there's a default by the creditor which isn't waived, or a default by the debtor that isn't waived by the creditors, or corrected by the debtor within 30 days, again, there's a potential that the court will annul the proposal, again, the result being a deemed bankruptcy. Now, the second of the formal options I'm going to touch on is a proceeding under the Companies Creditors Arrangement Act. That's obviously separate legislation, and it provides a different form of formal restructuring proceeding, and it has quite significant differences to the Division 1 proposal. The first is eligibility. That proceeding is only available to companies. The Division 1 proposal is also available to individuals, partnerships. Companies Creditors Arrangement Act is strictly companies. And the company must have total claims of at least $5 million. So it's generally an option for larger companies with more complex operations. Second key difference with the Division 1 proposal is it's a much more flexible and adaptable proceeding. It doesn't have, as the Division 1 proposal does, very strict deadlines in the Act that have to be met, and if they're not a deemed bankruptcy. It's a court-supervised proceeding, and it can be adapted to the particular needs of the debtor. In terms of actually kicking that proceeding off, also different from the Division 1 proposal in that it's not commenced simply by filing documents with the trustee. It requires an application to court. at which a court will make what's called an initial order. That initial order will generally provide for a stay of proceedings. The initial stay of proceedings in this case is 10 days. That stay of proceedings, though, can then be extended for much longer periods than the 45-day cap that applies in a Division 1 proposal. Again, so it's a lot more flexible. Bigger companies with complex operations can require that stay to be in place for months and months and months so that they can restructure properly. And there's also no overall cap of 6 months on the proceeding, as there is in Division 1 proposal. Again, so that more complex restructurings can occur. At that initial application and in the initial order, the court will also appoint a monitor. So there's a monitor rather than a proposal trustee. And the monitor will supervise the restructuring, assist management through the process, and also file reports to the court and the creditors just to keep everyone apprised of the process. Very frequently in a CCAA proceeding, that initial order will also provide for an interim or DIP financing and a charge that gives that financing priority over other secured creditors. And that, of course, is just so that the debtor has funds that it can use over the course of the process and in the context of its restructuring to hopefully get to the other side. A key point to emphasize about the CCAA proceeding is that it doesn't necessarily, like a Division 1 proposal, have to end with a proposal to the creditors. There's much more flexibility in the different objectives of the CCAA. And again, that proceeding lets a debtor be a bit more creative in its plan to restructure. One option is a plan of arrangement, which is similar to a proposal. That would be, again, proposed to creditors, and then there would be a meeting of creditors with the exact same majority requirement. Again, allowing a majority to cram down minority creditors. And then that, again, is subject to court approval. The difference being here, if there's no approval, there's no deemed bankruptcy, no automatic bankruptcy. Another form is known as a liquidating CCAA, and that will essentially just involve a sale of particular assets or all of the assets of the debtor. It's a bit of a liberal interpretation of a restructuring, but courts have held it's a proper use of the legislation. And then third, there can just be a more, I guess, bespoke plan where the court approves the sale of particular assets, payment of certain debts and not others. So in summary, it's just a different proceeding with a lot more latitude and a lot more flexibility for the debtor to deal with its affairs. So those are the main formal proceedings. This slide is really just to touch on the fact that there are some specialized restructuring acts. The Wind Up and Restructuring Act is something that applies to essentially regulated bodies, banks, insurance companies that wouldn't restructure under the other acts. And then Farm Debt Mediation Act will create a set of rules that will apply when the debtor is involved in farming operations. So point being, it's not an exhaustive cover of all of the options just by looking at the Bankruptcy Insolvency Act and the CCAA. And the very last point is bankruptcy. Obviously, that's typically the last resort for an insolvent debtor. The debtor can opt to assign itself into bankruptcy, and it's generally, of course, the end of the line for that particular entity. The property will all vest in the trustee and be liquidated to be divided among all of the creditors. It's not typically thought of as a restructuring proceeding, but Assets can be purchased out of a bankruptcy proceeding by a new entity, which can then carry on the old business, probably in some other form. And it can be the right option in certain circumstances. And that brings me to the end.
Thank you so much, Lee. There's lots of questions, so it looks like it was everyone's really enjoying what you've been sharing. So the first one comes from Denise. She's asking if you can give an anonymous example of forced unwilling creditors into a plan or chaotic workout plans that were handled.
I can't think of an example of a chaotic workout plan. Frankly, I think those are less common than the formal proceedings. And maybe I just haven't experienced them happening so much. In terms of creditors being forced into a plan and crammed down, I mean, that happens very often, probably in most of the formal proceedings, the restructuring proceedings. I've had ones where secured creditors have objected the whole way through the process, but ultimately they were in a minority in terms of overall value. 2/3 of the value, and a majority overruled them, approved the proposal, and they essentially lost their debt, became holders of equity. And because the court approved that proposal after the creditor approval, it was binding on them, and there was no going back. So that's something that happens quite regularly.
Thank you. From Kelly, why would a debtor choose a proposal versus just going bankrupt?
Well, the proposal lets a debtor continue to operate its business over the course of the proposal. And obviously, because the property doesn't vest in the trustee, who then just looks to sell it and divide the proceeds, the goal is to keep the business intact, restructure it somewhat, and continue moving forward. A bankruptcy, there's no option really to do that. I should mention, a bankrupt can file a proposal to come out of bankruptcy, so that's an option. But typically, if a company's bankrupt, it has no control, it doesn't operate the business anymore, and the trustee just liquidates everything.
From Lena, she's asked, has there been an increase of insolvency and bankruptcy this year?
I mean, I don't know statistically. I don't have those numbers with me. I think just from general experience, I'd say probably not. I think debtors are starting to look at, as I mentioned, moving out of the pandemic, what they might have to do, trying to get ahead of a formal insolvency situation, which is always the ideal course of action. But I don't know the stats, and in my experience, there hasn't been a huge spike in insolvencies.
And from Harvey is the next one. What are the implications for directors who were at the helm of a company that goes into bankruptcy?
There can be a lot of implications. It's hard to list all of them. It would depend on the circumstances, but if there are often guarantees by a director of a corporate obligation. A bankruptcy of a corporation isn't going to relieve a debtor of that guarantee. So creditors can, looking at the fact the company is bankrupt, then look to the guarantees as the real source of recovery. So I think a debtor or director in that situation is going to likely receive the brunt of the creditor's actions, if that director has assets, of course. There's lots of rules in terms of directors' obligations. I mean, that would be a whole other topic, but directors can be liable for certain obligations a corporation has to its employees, And the bankruptcy would change all of the priorities of a corporation's debts, which can also have an impact on directors. So it's a bit of a general answer, but a bankruptcy of a corporation will certainly change the dynamic for a director of that corporation and what they're likely going to face.
And keeping with that theme, I've got another one. What are some mistakes you have seen a company make that increased risk of bankruptcy rather than curtail it? Looking for a tip of what not to do.
I think the main one is leaving things too late. If there aren't attempts to deal with a situation relatively early, informally or through a formal proceeding, it can get to the point where a company is left with no other option, really. No viable way to get funding in to deal with it through a proposal proceeding. And there are just an overwhelming number of creditors and no practical option but to assign into bankruptcy.
And this is our last one from Walter. He's asked, what recourse could CRA take on tax debts?
Well, the CRA, I think it depends on who we're talking about, but the CRA frequently is owed tax debts in an insolvency scenario. One thing the CRA has by statute is a deemed trust over all of the debtor's assets, everything. That can change for certain deemed trust in a bankruptcy scenario. It can no longer effectively apply, and that's actually one reason why bankruptcy can be the right option for a company. But pre-bankruptcy, the CRA has quite powerful remedies over all of the debtor's assets and can look to enforce them, and that can actually drive a company into bankruptcy as an option to deal with it.
Thank you. So that concludes our session with Lee. Thanks again for joining us here, Lee. It was great and lots of good questions. The next session is starting at 10:30, so we're a little bit early to break. The subject will be regaining your strategic stride after COVID-19. And in the meantime, just a reminder that any attendees can jump into the Zoom lobby if you'd like to chat informally with each other. Otherwise, we'll see you at 10:30.